the issue.
Well, right, after the dismissal. And in equity, I would say, Your Honor, we've got a multitude of violations, and their answer, and we request what we're entitled to in a law, a compliance review board hearing. Now, whether there are violations and if so intentional, that's the purview of that board. But we requested that, and we were entitled to that. That is procedural due process afforded to our client under the law. And you see, and that's a different process than what we've got under the merit system rules and regulations. And there's different implications if that procedural due process is denied. And we don't need to get into that today either.
Right, but in, for instance, in a court case, and now I'm going to get really on thin ice, but if someone didn't get procedural due process in the form of reasonable notice and opportunity to be heard, and thereafter is, let's say, convicted or judgment centered, the remedy is not, after the judgment is entered, to order someone to give them notice of the hearing that's already been conducted. You can't do it. I mean, it's, that toothpaste is out of the tube. The remedy may be to set aside the judgment or the conviction. And I just read that this statute does not give you relief, injunctive relief, in the form of reinstatement after discharge, a la comparing it to a
we're not seeking, we want to
setting aside the conviction. Yeah, and so this is isn't this akin to requiring them to give you the notice they should have given you back when the suit was ongoing, now that the suit's over?
Okay, I got it. Your Honor, there's a couple, no, the answer, that's different. Here's one. McQuaid.
I don't think you'd agree that.
I know, yeah, I know. It's, McQuaid answers the question for us, and so does another section of the statute. I'll discuss both real quick. This is important stuff, Your Honor. I mean, before I get to that.
All right, well, why don't we take a break and come back after lunch?
Can I finish up?
I haven't had lunch.
I haven't had breakfast. I one sentence till I was done. That's all I'm saying. One more
that
sentence.
could explain.
Well, there's a lot to explain that. But if you're done, you're done, and I'll finish this sentence when I come back. I was going to tie that thought off, but I can do it later.
Okay. Well, I would prefer to go ahead and finish this, but it looks like it may take a little more time. And again, I take you at your word that this is an important matter, and we need to give it reasonable consideration. But I'm considering ending this case today if, in fact, I adhere to the notions that I have expressed already, and you need to disabuse me of that. So I think we need to take the time necessary to give you a chance to do that and to let the county respond. Because again, if I continue to believe that this has already been done, and if they violated this, then that may give them a right to reinstatement, but not in my court.
We're not asking for reinstatement.
I know you're not.
And
if I adhere to the view that therefore there's nothing else for me to do, it's just like ordering them to give you notice during the lawsuit that they failed to give you now that the lawsuit's over. It's not the same, but I think it's somewhat analogous, or it may be. So if I adhere to that view, then there's no reason to go forward with this action for temporary or permanent injunction.
The case they cited, as I'll explain when we come back, explains why that is the incorrect review of the statute.
Okay.
We do have a right to do that now.
And the case they cited is the...
McQuaid, and I'm referring to, because he did not seek an injunction from the circuit court before he was dismissed or showed prejudice in the violation.
So
we were
why
prejudiced.
don't I read McQuaid over the break and try to read some of this other material, and then we'll come back, and hopefully I will be in a better position to do.
What about all this stuff?
It'll be safe.
You can leave it.
All right.
Thank you very much, Ron.
Can you make it back then, Mr. Johnson?
Yes, certainly.
You know what that other thing? We will be in recess until about 1:30. I'll try to be back at 1:30.
Thank you. All rise, please.
I gotta make arrangements.
Oh, is that
I have to leave the land by 1:15 otherwise. Look, McQuaid.
Court will be in recess.
Thank you.
Thank you. The hearing room is locked, so if you want to leave any paperwork in here or whatever you want to leave, you're more than welcome to do it.